Hello, welcome to Fong Law channel. My name is Daniel Fong. I'm an estate planning attorney. I'm certified by the State Bar of California as a specialist in trust, estate planning, and probate. In this channel, I would like to discuss legal issues relevant to your daily life, especially legal issues relevant to the coronavirus. As we all know, the coronavirus is still spreading in our community. Many people are afraid of going out. I have a friend whose relative is an elderly woman. She lived by herself and she has no children. She wanted to set up a will as soon as possible while she was still alive. However, she was afraid of going out. What she did was that she used her cell phone to make a video of herself. In the video, she explained how she wanted her estate to be distributed upon her death. My friend asked me whether this video has any legal validity and whether the video can be used in lieu of a will. To answer this question, we must know the legal requirements of a will in California. According to California law, a will must be in written form. It cannot be in the form of a video. Also, according to California law, there are two types of wills. One is called holographic will. The other is statutory will. What is a holographic will? A holographic will is a will that you make in your own handwriting. So if you write out your will in your own handwriting, that's a holographic will. According to the California law, a holographic will does not need to be attested by witnesses. You can just sign the will by yourself. In a holographic will, you must clearly express your wish that the distribution of the estate will happen upon your death. If you fail to express your wish that it's going to happen upon your death, if you just say in general terms that it's going to happen sometime in future, that may not meet the requirement of holographic will. The other type of will is statutory will. What is a statutory will? A statutory will is any will that's not a holographic will. Basically, any will that's not in your own handwriting is a statutory will. For example, if you use a computer to print out your will, that's a statutory will. And if you ask someone else to write your will, that's a statutory will. According to California law, a statutory will must be attested by two disinterested witnesses. What is a disinterested witness? A disinterested witness is someone who does not have an interest in the will or someone who does not have a stake in the will. For example, if I ask Mr. Anderson to be a witness of my will make no mention of Mr. Anderson. He is not my beneficiary, nor is he the executor of the will. Then Mr. Anderson is a disinterested witness because he doesn't have a stake in the will. However, if my will mentions Mr. Anderson as a beneficiary, then Mr. Anderson becomes an interested witness because he has a stake in the will. According to the California law, if the will is attested by an interested witness, there's a legal presumption of fraud. The law will presume that the interested witness obtained the will by means of fraud or by undue influence upon the testator. Because of the legal presumption, the court will hold the will invalid unless the legal presumption is rebutted by clear and convincing evidence. So if you want to make a will and leave your estate to your children, don't ask your children to be the witnesses because they are interested witnesses because they have a stake in the will. So it will likely make the will invalid. No matter whether it's a statutory will or holographic will, the testator must have capacity to make the will. That means that the testator must know what he or she is doing. The testator must not be under coercion, that the making of will is out of the testator's own free will. What if someone who dies without a will? If someone dies without a will, then his estate will be handled according to the state succession law. Each state has succession law just in case people who die without leaving a will. And believe me, there are plenty of people who die without leaving a will. According to California law, if you die without a will, and if no one is qualified to take your estate under California succession law, California believes that it has the right to take your estate. That means that your estate will become the property of California. If you don't want that to happen, if you don't want your lifetime asset become the property of California, you should make your will or trust. California requires a will to be in written form. However, in some other states, you can use digital wills. What is a digital will? A digital will is a will that you make in your computer and you don't need to print it out. For example, Nevada is a state that allows digital wills. A digital will must be signed, but however, you can sign the digital will by e-signature. That means that you don't have to sign on paper, you can just sign on the computer. Due to the advance in technology, there are many legal documents that you can sign on computer by e-signature. A digital will also needs to be attested by two independent witnesses, and the witnesses can also sign the will by e-signature. However, not everyone can use digital wills. According to Nevada law, if you have terminal illness, you not use a digital will. Say you have terminal cancer, then you are not allowed to use digital wills. Also, if you are regarded as a legally vulnerable individual, you cannot use a digital will. What is a legally vulnerable individual? If you cannot care for yourself and you need to be cared by someone, then you are a legally vulnerable individual. Then you cannot use a digital will. And some people ask me, you can go to the bookstore to buy a pre-printed will, or you can download a will from the internet. Is it advisable? I want to remind our audience that there are 50 states in the United States. Each state has its own requirements regarding wills, and these requirements vary from state to state. So if you buy a pre-printed will or download a will from the internet, chances are the document may not meet the requirement of the state where you live. There's another problem with this document. Usually these documents contain a disclaimer. What is a disclaimer? A disclaimer is a waiver of legal liability. Usually the disclaimer says, if you use the document for whatever purpose, the provider will not be responsible for any legal consequence. It's just like you buy a parachute, and the parachute comes with a manufacturer manual. In the manufacturer's manual, there's some fine print saying that the manufacturer does not guarantee the parachute will work. If the parachute doesn't work, and if it results in death or injury, the manufacturer will not be responsible for the consequence. If this is the case, will you still buy the parachute? If you buy a pre-printed will or download a document from the internet, it's just like you buy the parachute that the manufacturer does not guarantee it will work. I like to use a real case to illustrate the problems of using these documents. And this case happened in California. Let's say that the testator is called Nancy. Nancy was an elderly woman. She lived by herself and she has no children. Her only family is her brother, Danny. And it was Nancy's wish to leave her entire estate to Danny when she died. Nancy was wealthy. However, maybe she wanted to save some money. She went to the bookstore to buy a pre-printed will. In the pre-printed will, most of the provision had already been written out. All Nancy needed to do was put Danny's name on it and to add a couple of sentences. So when Nancy died, Danny believed that she could inherit Nancy's estate because he was the sole beneficiary under Nancy's will. However, at this time, things took an unexpected turn. What happened was Nancy's nieces and nephews, who were the children of Nancy's deceased brother. They argued that they also had the right to inherit Nancy's estate, so they filed a lawsuit to contest Nancy's will. To make a long story short, this case went all the way to the Florida Supreme Court. At the end of the day, the Florida Supreme Court held that Nancy's will was invalid. Why did the court hold the will was invalid? That was because the will did not have a residuary clause. According to Florida law, a will must have a residuary clause. Without a residuary clause, the will becomes invalid. The preprinted will that Nancy went to the bookstore to buy did not contain a residuary clause. Therefore, the Florida Supreme Court held that the will was invalid. Because the will was held invalid, the law would treat Nancy's estate as if she had never made a will. Because Nancy never made a will, according to Florida succession law, Nancy's nieces and nephew, they also had the right to inherit Nancy's estate. So as a result, Nancy's brother and Nancy's nephew and sister, they would split Nancy's estate. In the opinion, the Florida Supreme Court, in a sentimental note, said that the justices were sympathetic to Danny. They wished Danny could inherit Nancy's estate alone. But however, they could not do that because the law is the law. Even the Florida Supreme Court has to obey the law. That's the meaning of the rule of law. The judges cannot change the outcome of a case because of their personal opinion. They have to follow the law. And the Florida Supreme Court also admonished people not to use pre-printed documents. They should go seek professional help when they want to set up their wills. And there's a saying, a penny wise and a dollar foolish. If you want to make your own legal documents, you may save some money, but in the end, you will lose more. A residuary clause is highly technical. Only a professional trained lawyer could know how to draft it properly, and lay people could not possibly know how to draft a residuary clause. So if you want to make your own legal document, it's just like you operate of your own body. It's very risky. I understand that because of the coronavirus, many people are afraid of going out. However, you can consult an estate planning attorney by telephone, and the estate planning attorney will prepare the document according to your wish. And after the document is completed, the attorney can mail the document to you. And then you can ask your two witnesses to witness the document. Then you can have your own will. Then you don't have to go to the bookstore to buy a pre-printed will or download it from the internet. And I hope that you will be able to, all of you will be able to seek professional help when you formulate your own estate plan. And I hope I can see you very soon in the future. Thank you very much.